You're now listening to the Engage the Rockies podcast, your go-to podcast for local and state issues concerning Colorado.
Hello, Rockies. I'm Sarah Jane Maroney, your new host for the Engage podcast, which is your go-to podcast for state and local issues concerning Colorado. Today, we are going to be joined by George Brauchler, who is now currently the DA-elect in the newly created 23rd District. He's going to speak to us about truth in sentencing, and we had a side conversation about some of the ways that we elect judges. So, giving you a little bit of background on George, he has a strong military career. He has actually been a district attorney in Colorado's 18th district. He's worn many hats: military prosecutor, criminal defense attorney, military defense attorney. He was also the chief of military justice for Fort Carson and for the 4th Infantry Division, as well as prosecuting the Aurora Theater Massacre and Columbine cases. So he's got a lot of opinions, and we're excited to have him here. Thanks for being here today, George. We really appreciate it.
Thanks for having me.
So, truth in sentencing, Prop 128 passed as this, actually, speaking of elections, I should congratulate you.
Yeah, thank you.
Well done on your win in the 28th district. We're thankful for your service.
23rd Judicial District, first new one in 60 years in the state of Colorado.
How does, tell me a little bit about that before we get into the nitty gritty of 128.
Yeah, states carve up their state prosecution function in different ways. Some of them just do, every county has one. Well, we have 64 counties. But what we've done historically is to run along county lines to create judicial districts. And we've had 22 since Kennedy, I think, was still alive. And then we changed the law to add in this one just this year.
Wow.
It goes into effect January 2025. The legislature passed it a few years ago.
Oh, wow. Okay. So this is very new.
Brand new. No one alive has ever stood up a new DA's office before. So it's a bit of a challenge, but man, we've had such great support and I'm really optimistic.
And so that means you'll launch as of January, having cases and offices and all the whole 9 yards.
Yeah. So as you can imagine, the criminals don't take a time out. So they continue to commit crimes that ostensibly get prosecuted by the current 18th Judicial District. That's 4 counties: Arapahoe, Douglas, Elbert, and Lincoln. Well, on 14 January of 2025, one of those counties drops off and becomes the 18th. That's Arapahoe. The other 3, Douglas, Elbert, and Lincoln, become their own standalone judicial district, the 23rd. Those crimes that occurred leading up to then that are still being prosecuted would end up slipping underneath the umbrella of the 23rd Judicial District, as would any new case that happens. And so we will also be getting cases that this Proposition 128 applies to.
Oh, okay. So tell me a little bit more about 128. Obviously, we all saw it on our ballots, and it's a good idea to keep criminals behind bars, but Explain a little bit more about that.
Let me give you some background first to tell you how we ended up here, because we shouldn't have needed a ballot measure to get to this place. But what has taken place in Colorado over the past 15 or so years is that the legislature, as you may have followed, has changed. And so we now have, and I've said this every year since I was first elected in 2012, and every year I've been proven right, it's the most offender-friendly legislature that we've ever seen. And if you combine changes in things like creating personal liability for police officers, if you talk about the tools that are taken away from prosecutors and then turned over to judges or disappear entirely, the reduction in the number of mandatory sentence crimes, and you combine that with what is already a convoluted and largely failed system of sentencing by the Department of Corrections, you get a situation where the law before Proposition 128 read, if you are convicted of a violent crime, and violent crimes are the ones that you would think, right? Like armed robbery, home invasion, burglary, forcible rape at gunpoint, murder, attempt murder, all of those kinds of crimes. That if you're convicted of those, that you have to serve 75% of your sentence before you're parole eligible. But because of the way that law was written and the way the Department of Corrections has treated it, there are things like good time and earned time And this legislature has created more and more ways to discount the sentence that you earn in the courtroom based on things that you do. Some of them we could probably wrap our mind around, like if you achieve a certain educational level while you're in prison, I get that. But the good time, earn time thing has worked such a disservice to sentencing that 75% mandatory minimum doesn't function that way. In fact, on average, violent criminals in the state of Colorado are parole eligible after about 47% of their sentences. So if you received a 20-year sentence for some horrible crime, you're probably looking at parole eligibility being somewhere around 9-ish years. And then if you factor in that 18 months before you are put on probation, you can begin the transition process to community corrections. You can do the math. These big sentences we read about in the paper or hear about in the news, they're fake. They're not real. And so the thought here was the legislature could step in and fix this, but not the most offender-friendly legislature we've seen. They don't want to do that. They want to make it harder to sentence people to prison and make it harder to sentence them there for longer periods of time. So we do in Colorado what I think is unique, at least for us. Not every state has the ability to do this. We have a petition process, and the good folks at Advance Colorado were able to muster the resources together to get the signatures necessary to put Proposition 128 on. And 128 makes it crystal clear. If you are convicted of a violent crime, you are going to serve 85% of the sentence before you're parole eligible, without getting rid of that good time, earn time nonsense. And honestly, if you were interested in knowing how jacked up the good time, earn time thing is, I'm happy to talk you through the details. But every time I've told the story to people, they're like, that can't be right. I'm like, that is the truth. This is how it works.
Do you think that the legislature will attempt to thwart 128 having passed being
Yes.
Okay. And how,
Yeah.
or what would they do?
What I think they're going to do, and we saw this a couple years ago when they went through something called misdemeanor reform. And that was another bill that had buy-in from a lot of different stakeholders, including the District Attorney's Council and others. It worked to change the classification of charges and reduce down the potential penalties. Here's an example of what they did with misdemeanors. Under the old law, third-degree assault, which is the highest level misdemeanor you could get, guy puts a beating on his wife. No broken bones, no weapons, but puts a beating on his wife. That guy could face up to 2 years in jail. Now, you can't serve more than 364 days in jail. And the reason that number is important is because that number impacts immigration. And so if you are convicted of a crime that is punishable by a year or more in jail, that is a potentially deportable offense. So the state legislature, under the caption offender-friendly and illegal immigrant-friendly, said, hang on, what if we reduce down all the maximum misdemeanor sentences to less than 365 days? And that's exactly what they did. So you can see them in light of this effort by the state, and it won pretty well, pretty good. It wasn't a close call. I believe they're going to come in under the guise of felony reform, and they're going to ratchet down the sentences to accommodate for that mandatory 85%. So for instance, right now, attempted first-degree murder is punishable as a second-class felony by 16 to 48 years in the Department of Corrections. Pretty broad window, 16 to 48 years. Under the current system, even if you got 48 years, you would likely be probation eligible somewhere around 23 years. So what I can see them doing is saying, let's just do the math for ourselves. We'll come in and amend down all of the felony caps from 48 down to something that reflects us not wanting someone to go to prison for very long for attempted murder or forcible rape at gunpoint, that kind of stuff. That's what I think will happen. I also think you'll see judges factoring this into their minds as well and starting to say, well, I know that they're going to end up having to do 85%, so I won't give as big a number, knowing that they're going to have to serve that much.
So what would you as DA do to help combat that situation? And is there anything that we, the people, should know in terms of how we voted and the impacts thereof?
Well, this change in the law is going to become effective for crimes committed after January 1st, 2025. And so that is before the legislature is able to step in and make any changes that they might want to they might want to make, but it doesn't impact what judges can do with this. I think what we need to do in our individual judicial districts and communities is pay particular attention to the sentences that judges give on violent crimes. But they didn't just start in January 25. These people have been on the bench for a long time. And what we probably need to go do is go back and look at what they have done in the 2 years leading up to this on the same crimes and see if they are making changes on that top end number to reflect an accommodation for the will of the voters. That would give us a talking point.
Okay. I know that, and that's not what our focus is today, but I know that a lot of people end up having questions about judges. There's some information in the Blue Book, but it just sort of seems like every time you read about a judge, it says they vote to retain. Does a judge actually campaign? Have you heard of that? Or are they all just retained just by default of the vote?
This is another great question, and it may be something that we need to return to the ballot through a petition process to address, because the system by which we retain judges, in my opinion, is largely ineffective, and it doesn't lead towards an accurate reflection of what the community wants, because the community doesn't get told enough to make an informed decision. So right now, the law prohibits a judge from campaigning for their position because we're in a state where you don't elect judges. You publicly retain them after a period of time. So Judge Polis put someone on the bench. After 2 years, they must stand for retention. But then depending upon the class of judge they are, the level they are in the system, whether it's county court 4 years, district court 6 years, Supreme Court 10 years, you have to stand for retention. Because it's just an up-down vote, yes or no, and there's no one else on the ballot with you, there's no campaigning that's permitted. However, if someone or some group were to launch a coordinated campaign to remove a judge, then the judge can have a campaign to combat that. But if nobody takes up political arms against a judge, they can't campaign. So we're left with, how the heck do we know anything about the judges that are showing up on our ballot? And they have these groups called performance review commissions. And they're the ones that tell you whether to retain or not retain. And they're made up of good people. I will say this, good people. They're trying to do the right thing. I've met with them the whole time I was DA. Every time there was a judge on the ballot, they would come and meet with defense attorneys and prosecutors and all this. And I believe earnestly they're trying to do the right thing. But here's a couple problems. When Polis has appointed people into nominating commissions and performance review commissions, he has disfavored Republicans to the point where I think for the nominating commissions, out of the entire metro area and El Paso County, there are 4 Republicans out of
were those appointed by Polis, or they were appointed by previous governors?
Usually by Polis at this point, or Hickenlooper, because the law says you can't have more than a certain percentage of just one party. So instead, they nominate a ton of left-leaning unaffiliateds. And so you end up with one or none Republicans, no Republicans on these things. So the same thing happens with the performance review stuff. Some of them are appointed by the Chief Justice of the Supreme Court. Some are appointed by Polis, and that's the attorneys versus the non-attorneys. And they're supposed to represent the geography. But they're limited in what they can ask about. And here's a perfect example. One of the things you might want to know about a judge you vote for is how many times are they overturned? Not just in their own right, but compared to other judges. Like, are they good at their job when they make a ruling or a decision? Is it one that's consistent with the law? So you might want to know error rate. These performance review commissions are forbidden from asking that kind of information. They are given a very narrow field of things that they can consider.
I thought some of that information was in the Blue Book about how often they were overturned.
Not at the level.
Okay.
No.
Okay.
In this way, like, I'll give you another example. Like, nobody accumulates that information. Nobody goes and gets that. And what you can't do is say they couldn't follow up on any overturned numbers. Those numbers, by the way, came from a study that the Gazette did, the Denver and Colorado Springs Gazette, and a fantastic investigative reporter named Dave Magoya sat down with a bunch of guys, and they crunched the numbers, and they're the ones that came up with it. Like, the state judicial branch isn't putting out, this person gets overturned more than anyone else in the state of Colorado. And the Performance Review Commission, when they interview the judge, can't say, here's a case that you got overturned on. What the hell? Like, how did that happen? You know what I mean? Or you're overturned more than anyone else in the jurisdiction. Why is that? They don't get to talk about those things. So you'll get split votes sometimes on judges, 4-3, 5-2, and they'll report that split vote. But at the end of the day, it's retained. And in fact, I think someone told me anecdotally, because it wasn't in my jurisdiction, there was a judge who received a do not retain vote, and they were retained anyway. So it short of a judge murdering another judge in front of a jury or a bunch of witnesses, I think not being retained is largely a fiction in the state of Colorado under our current system.
Wow, that's very eye-opening. Thank you for that information.
It's tough.
So to circle back to truth in sentencing and your viewpoint that the legislature will try to thwart it a little bit in terms of or the judges themselves giving lower sentences. What can you as DA do? Is there anything else that you can do to try to adhere to Prop 128, which did pass?
Yeah. There are some limitations, right? Like when I was district attorney of the 18th from 2013 to 2021, I was a frequent fixture at the legislature during bills like this, where they would try to meddle with our ability to do good things. So if they tried to change the misdemeanor reform thing, if they tried to change, I'd be out there and testify. But as you can imagine, when over the last couple of years we were at super majority or super minority status as Republicans in one house and one vote away in the Senate, I'm not a super popular guy down there to give testimony. And they don't want someone like me to show up and provide the statements and testimony. Yeah, they're not interested in that. In fact, it's largely been legislation by anecdote with the Dems. They don't care about the numbers. And if they do rely upon numbers, they're not numbers from the state of Colorado. They'll go out to some other crazy place and say, well, this is what's going on in Vermont, or this is what's going on in California. It's like nobody cares, because that's not us. That's not how we do business. They don't want numbers. They don't want facts. They want emotions and anecdotes. So I can and will still go to the legislature to try to advocate for some sense of sanity and discretion. And for folks out there who are wondering, why shouldn't judges have more discretion than the prosecutor in terms of sentences? And when I'm talking about mandatory minimum sentences, I'm talking about you empower the prosecutor. Here's the short answer. Based on the description I've given you, there is no person within the criminal justice system who is more accountable to the people than your elected prosecutor. Your elected prosecutor is term limited. Judges aren't term limited. They can serve as long as they want until they attain the age of 72. So I'm term limited. Public defenders, they're not term limited. Defense attorneys, they're not term limited. You can't vote or pick for the public defender. You can't have influence on who the public defender is or the policies that they adopt. And based on that description I gave you of the judges, yeah, they're on the ballot, but wouldn't it be nice to run against no one? I'd like that. But instead, your DA gets vetted. Hell, I was primaried. I had a general election opponent, a Democrat. That's going to be the norm moving forward everywhere for Republicans. That's why the person that should have, in my opinion, the most discretion on these types of charges and ultimately the sentence range is the person most accountable to you. So we can continue to pursue the charges we think are just, and then approach the court with an attitude of, this is the right sentence, Judge, and you should be giving that sentence independent of whatever you think is going to happen once they go to the Department of Corrections. And then after that, I think we probably, have a vigorous conversation about transparency in the courtroom so that people can say, man, George seems to suck at his job, right? Like he's losing a whole bunch of cases. That would be a fair conversation, right? But now we need to encourage that kind of transparency for judges too, which is, my God, they get overturned a lot. Like that seems like that's a concern. And along with that, a corollary is we should be able to know what kind of sentences are being asked for and what kind of sentences are being given. And if the judge disagrees with the prosecutor, that's part of the game. That's part of the process. But the public should get to know about that. And the public should be able to weigh in and say, George, I think you're too light on the sentences you seek, or I think you're too heavy. But they should also be able to say, Judge, what the hell, man? Like this guy's been in front of you multiple times, or this guy has a huge rap sheet. Why aren't you giving him more? Or conversely, we think this judge is too harsh, but we don't get to know these things. So you get people showing up to the ballot voting off of, I don't know, here's what I heard. Just doesn't seem like a good way to do it.
Well, Prop 128 did seem like it passed by a majority, and most humans look at that and say, "Oh, yeah, I want an offender who's been convicted in our courts to serve their sentence."
Right.
So
So
at
here's
least
what happened,
it's
though.
a positive way. Yeah. Go ahead.
It's
Sorry.
definitely a step forward. And for the people that bemoan the initiative process, the petition process, I just disagree. And this is proof that our legislature, although dominated by one party, is disconnected from the public it's supposed to serve on issues of public safety. There were 3 measures on the ballot at the same time. There was Amendment I that sought to fix something that was broken by Governor Polis and the legislature when they repealed the death penalty that made murderers eligible for bail. That was on the ballot. There was this measure, and there was Prop 127, which was kind of like a back the blue measure that provided mandated $350 million of one-time appropriation of funds from existing revenue for recruiting, retention, support for law enforcement, as well as one-time $1 million death benefits for those who die in the line of duty, like the Golden officer who was killed the day after the election by a drunk driver. Those things all passed. Now, if you're the legislature and you're in charge, you should look at that and go, maybe we don't have our finger on the pulse here of what the state is doing. If you're Advanced Colorado and other public safety-minded groups, you should think, maybe this is our path. Maybe we don't need the legislature anymore. Maybe we just need to put these common sense things on, get some funding to notify people about them, and watch Coloradans do what we all expect, which is to try to protect the public. Can I just share a story with you about how jacked up this system is? The reason 75% as it exists today really spends like 47 is this. You automatically, this is how Department of Corrections does it. They automatically give you 25%, and I'm using air quotes here, earned time the minute you walk out the courtroom door. So you don't have to do anything to earn it. You are just gifted it. So if you get a 10-year sentence by the judge, you walk out and go into DOC custody, you are instantly at 7.5 years. That's when they start calculating your parole date. But wait, it gets better. Then there's good time. Good time is doled out as so many days per month in addition to that. And it's largely given for things like
well, you mentioned earlier, like education and things like this.
Yes, it could be. But there's also good time given for just not doing bad. Like that's good time. But here's where it gets crazy. The Department of Corrections has posted on its website, anyone can check out the things I'm saying, that has a maximum number of good time that you can lose per bad event.
Bad event like fighting another inmate
let me give you 3 quick
ruckus.
examples. If you rape your cellmate, rape another inmate, you cannot lose more than 45 days of good time.
What?
If you attempt to murder another inmate, you cannot lose more than 60 days of good time. And if you actually murder another inmate, you cannot lose more than 90 days of good time. Now,
how is that even possible when that's a whole separate, like that would be another, whatever the person would be incarcerated for, then there'd be another trial, a separate item, wouldn't it?
That's right. So let's say you rape an inmate. Yes, there is the potential other criminal case that's out there, and it gets prosecuted. You're still going to get all the good time from your prior sentence to be brought in onto that next sentence. Wow. And you can't lose more than 45 days for raping another inmate. Now, I'm an old school guy. In my mind, it seems like if you rape an inmate, stab an inmate, kill an inmate, maybe you lose, I know it's going to sound draconian, all your good time, right? Like maybe you don't get good time because you've done these horrible things. That's not how DOC
strike me as good.
No matter what good you've done up to that point, that's so bad that we're taking away all your good time.
And are these rules instituted by the DOC in Colorado?
By the Department of Corrections. Okay. That's right.
Some of them are not elected offices.
Well, no, but some of them are statutorily driven. So there are statutes that apply towards eligibility for good time at a certain rate and pace. The difference between prison and jail is the different county jails have an ability to give out good time at a different pace. Like they don't have to give out as much as the Department of Corrections. And so one of the things that a district attorney can do, like this guy, is start to look at whether it makes more sense. Oh, we didn't even talk about, by the way, non-crimes of violence. Non-crimes of violence, your parole eligibility starts at about 30% of your sentence. So on a 10-year sentence for burglary, which is not a crime of violence, you probably do about 3 years. You know what I mean? That's before you're parole eligible. Crazy.
Okay. Yeah.
So one of the things that a district attorney could do is to evaluate whether it makes sense to pursue a felony with a prison sentence versus saying, you know what? You plead guilty to this lower level charge, could be a misdemeanor, could be a low-level felony, and you go to jail for 2 years, you might get more bang for your buck.
Okay.
That's what some DAs should start to look at doing is, am I better taking away the state's influence over sentencing and justice by making things more about the charges that we can handle here, prosecute here, and punish here as well? So I'm definitely going to take a look at that, and other DAs should probably do the same.
Wow. All right. Well, George, we're almost out of time here. Is there
I can't believe it. You've let me run my mouth for so long.
It's great. It's a lot of information that I don't think most Coloradans are aware of. And
No.
I think there's a lot of information out there that we need to gather and sort of figure out. So we're very thankful for you to coming on our podcast, and maybe come on again.
Oh, I'd love to anytime. And good luck on this. You're going to be great.
Thank you for listening to the Engage the Rockies podcast, your go-to podcast for local and state issues concerning Colorado.